First, welcome to our deep dive on how old criminal convictions can trigger immigration consequences years or even decades later. Today we will explore why serving time does not erase immigration exposure, what an aggravated felony means, how old removal orders resurface, and what strategies like post-conviction relief can and cannot do. We will move step by step and connect the dots so you can better understand the landscape and plan proactively. Next, here is our roadmap. We will begin with the big picture of how immigration law treats old convictions, then define aggravated felonies and serious drug offenses. After that, we will examine how old removal orders and notice problems resurface. We will highlight post-conviction relief as a key strategy, then distinguish motions to reopen and BIA appeals as often delaying rather than curing the problems. We will discuss hardship evidence and permanent bars, emphasize citizenship as the most reliable shield, and conclude with contingency planning for families. Along the way, we will use diagrams, a table, and short quizzes to reinforce learning. Before we proceed, a critical note. This video is for educational purposes only and does not constitute legal advice. Immigration and criminal laws are complex and fact-specific. Your situation may require urgent and tailored guidance from a licensed attorney with expertise in both immigration law and criminal post-conviction practice. Do not rely solely on this content for decisions about your case. To begin, understand that in immigration law, serving your criminal sentence does not erase the immigration consequences. Old convictions can remain permanent grounds for deportability. Even if life has been stable for years, a past conviction can trigger a new enforcement action if detected by DHS or ICE. If DHS detects the record, a person may be detained and served with a notice to appear, or, if an old removal order exists, enforcement can proceed swiftly. If no old order exists, the case goes into removal proceedings with limited relief options. If DHS does not detect the record yet, the risk remains latent and can surface later. Moving on. Aggravated felony is a term in immigration law that covers a wide range of offenses, not only violent crimes. Some felonies with a sentence of 1 year or more can qualify, as can certain drug offenses. The consequences can be severe, including detention, mandatory removal, ineligibility for common forms of relief, and harsh future bars. The label can attach even if the criminal court treated the matter years ago, and even if rehabilitation is clear. Now, examine the timeline. It shows how a conviction is followed by release and many years of quiet residence. Detection can occur years later due to database matches, fingerprint checks, or an interaction with law enforcement. At detention, the process checks for an old removal order, which can be enforced rapidly. Parallel tracks may include filing for post-conviction relief in state court and motions to reopen with the BIA. The outcome can vary. If PCR succeeds in eliminating the deportation ground, reopening may be viable. Otherwise, removal can be executed. Furthermore, many long-term residents discover an old, unexecuted removal order only when detained. This can happen due to notice failures, address errors, or breakdowns in the notification system. While a motion to reopen may be filed on procedural grounds such as lack of proper notice, success is not guaranteed, and time is often critical. Even when reopening is granted, the underlying aggravated felony or serious drug offense may still block relief. Next, the strategy map emphasizes assembling the right team and sequencing actions. You need counsel who handles both immigration and post-conviction matters, sometimes called crimmigration experts. Coordination is crucial. The PCR track in state court should align with the immigration defense track, including motions to reopen, stays of removal, or BIA appeals. Meanwhile, collect hardship and rehabilitation evidence promptly. Citizenship screening is also important to understand if it is feasible later or if prior conduct prevents eligibility. Then, regarding PCR, start by obtaining certified criminal records, docket entries, and transcripts. Consult a post-conviction attorney who understands immigration consequences to identify viable grounds such as constitutional defects in the plea, ineffective assistance, or procedural errors. Choose the appropriate remedy, which might be vacature, plea withdrawal, sentence reduction, or correction of the record. File in the correct state court with affidavits and legal memoranda. In parallel, coordinate with immigration counsel to request a stay of removal if necessary. If PCR is granted, and the conviction is modified in a legally meaningful way, immediately notify the immigration authorities, and file to reopen or terminate as appropriate. Afterward, consider motions to reopen and BIA appeals as tools to address procedural flaws or present new, material evidence. They can secure time, correct due process problems, or align the record with PCR developments. However, they do not inherently erase an aggravated felony's immigration effect. Also note strict deadlines, numeric limits, and discretionary standards. Acting quickly and providing strong documentation is essential. Next, this table compares common forms of relief against the presence of an aggravated felony. Asylum is often barred due to serious crime bars. Withholding of removal may remain possible but carries a high standard. Convention against torture protection can still be pursued if there is risk of torture. Lawful permanent resident cancellation is generally barred by an aggravated felony. Many hardship waivers are inapplicable due to permanent bars. Voluntary departure is frequently unavailable. Prosecutorial discretion can vary based on policy and case equities, but it is not guaranteed. Continuing, let's separate myths from reality. First myth: completing a criminal sentence clears immigration exposure. In reality, immigration consequences can be permanent. Second myth: long residence guarantees safety. In reality, length of stay does not eliminate deportability. Third myth: any immigration lawyer is sufficient. In reality, a lawyer with both immigration and post-conviction expertise is often necessary. Fourth myth: hardship alone will save the case. In reality, many serious convictions create permanent bars that outweigh hardship. Now, the decision tree illustrates typical branching. At detention or notice, the first check is whether an old removal order exists. If it does, enforcement can proceed quickly, but a motion to reopen and a stay of removal may be filed while pursuing PCR in state court. If there is no old order, the case enters removal proceedings, where the aggravated felony determination becomes pivotal. A positive aggravated felony finding bars most relief, leaving limited options like withholding or CAT. If no aggravated felony, options such as cancellation or hardship waivers may be considered. For long-term safety, citizenship, when eligible, is the ultimate shield. Additionally, hardship evidence can be compelling where relief allows it, such as demonstrating extreme and unusual hardship to qualifying relatives. However, aggravated felonies often create permanent statutory bars that prevent hardship waivers from being granted, no matter how severe the family circumstances. Still, collect and document mental health records, financial dependence, medical needs, and community support, because they can be relevant in any discretionary evaluations that remain. Moreover, the most reliable long-term protection against removal for old convictions is acquiring U.S. citizenship through naturalization. When eligible, early eligibility screening is critical, because certain offenses may bar naturalization or trigger additional scrutiny. Waiting increases the period of exposure to detection. If you qualify, applying can transform your risk profile and provide stability for you and your family. Finally, in this course section, even while you fight removal, prepare a contingency plan. Financially, ensure bank access, powers of attorney, debt and asset lists, and secure digital copies of key records. For family, arrange guardianship letters for minors, organize school and medical records, and coordinate care. Personally, gather identification documents, maintain contact lists abroad, consider language support or refresher classes, and research housing and employment options in the destination country. This planning is responsible and reduces chaos in worst-case scenarios. Quiz time. The question is, which approach specifically targets the underlying criminal conviction to remove the deportation ground? Option A, appeal to the BIA only. Option B, post-conviction relief in state court. Option C, prosecutorial discretion request. Option D, filing for withholding of removal. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B, post-conviction relief in state court. PCR seeks to vacate, modify, or correct the criminal conviction itself. If successful in a way recognized by immigration law, the deportation ground can be eliminated. Appeals to the BIA, prosecutorial discretion, or withholding of removal do not directly erase the underlying conviction. Next quiz. The question is, what is the most reliable long-term protection against removal for eligible permanent residents with old convictions? Option A, renewing the green card regularly. Option B, applying for U.S. citizenship. Option C, moving to another state. Option D, Waiting to see if policies change. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. Applying for U.S. citizenship. When available, naturalization is the most effective long-term protection against deportation risk from historical convictions. Renewing a green card does not cure deportability. Moving to another state does not change federal immigration consequences. Waiting for policy shifts leaves you exposed. As we continue, consider the pie chart of risk contributors. A significant portion stems from old, aggravated felony designations. Another sizable share comes from unexecuted old removal orders. Drug offenses make up a substantial part. Notice failures and address issues also contribute, as do other triggers like new arrests that cause database matches. While the exact mix varies by case, the chart illustrates how multiple vectors can converge to produce enforcement action. To summarize key points, old convictions can trigger deportation at any time. Aggravated felonies and many drug offenses have permanent immigration consequences. Post-conviction relief is often the only avenue to remove the foundation of deportability. Motions to reopen in BIA appeals can provide time and correct procedure, but do not typically cure severe crime problems. Hardship evidence helps only when relief is legally available. When eligible, citizenship is the strongest long-term protection. Acting early and engaging a crimmigration-focused team is essential. In closing, remember that immigration consequences are independent of criminal punishment. Old removal orders and notice failures can reappear without warning. By aligning post-conviction relief in state court with immigration strategy, you can target the root cause of deportability. Meanwhile, prepare a practical contingency plan for your family in case removal occurs. Early action and specialized counsel can make a critical difference. Thank you for watching. If you found this helpful, please like, share, and subscribe, and tell us your thoughts in the comments. Your questions and experiences can guide future content and may help others facing similar challenges.